webinars. We're going to be discussing the new act and how and why federal non-share capital corporations need to continue to it. So we will be recording this presentation, and it's going to be made available after the webinar ends for anyone who's interested in the recording. All of the participants should be muted, but if you have any questions during the presentation, if you could please just type them into the chat box and I'll answer some of them at the end of the presentation. So just a brief overview of what we're going to be talking about today. I'm going to briefly explain to you what continuance is, why it's important. Then we're going to take a look at the new act a little bit in terms of what some of the major changes are. And then the main part of the presentation will be on the continuance process itself, how exactly continuance is applied for and achieved. And at the end, as I said, I will take some questions. So to start off with, what is continuance? I'm sure a lot of you have heard a lot of talk about it, but I don't know if everyone really understands what exactly it is. So as I'm sure you all know, corporations are all incorporated under an act of some kind, and that's the act that governs the corporation. So it sets out the rules by which the corporation has to operate. Now, for nearly the past 100 years, charities and not-for-profits at the federal level have been incorporated under the old Canada Corporations Act. The problem is that this act hasn't been substantially revised pretty much since 1917. So federal charities and NPOs have ended up being governed by a really outdated piece of legislation. Recently, the business corporations got a new act, which is the Canada Business Corporations Act. Actually, not even that recently, it was a while ago. So it's finally turned for charities and NPOs to be given some modern legislation. And this is called the Canada Not-for-Profit Corporations Act, or the CNCA. Now, the CNCA is already in effect, which means that you can incorporate new corporations under it. But for all of the corporations that already existed under the old act, they have to actively make the switch over to the new one. It's not automatic, you have to apply for it. This is called continuance, and everyone was given a 3-year window to complete it. Um, from the date the new act came to an effect, which was in 2011. So the deadline to have filed for continuance is October 17th, 2014, so this coming October. Why is it important to continue? Well, like I said, the old act has the grace period of 3 years, but once it expires, it's not going to be a valid act anymore. And if you don't continue by the deadline, the government will assume that the corporation is inactive and it will dissolve it. So if the corporation is also a charity and it's dissolved for inactivity, you could probably expect that you will also lose your charitable registration since the corporation won't exist anymore. And if you lose your charitable registration, this also means that you'll have to pay a revocation tax of 100% of your remaining assets. So the consequences are pretty severe. So basically, if you want to continue existing, it's not optional. You have to continue to the new act. On top of that, as part of the continuance process, which we'll go through in a bit, the corporation can make all kinds of changes to its governing documents, bylaws, name, and so on, without incurring the fees and extra paperwork that are usually associated with those changes. So it's a perfect opportunity to kind of review and update your corporation. So let's look a little bit at what it means to be switching over to this new act, the CNCA. First, there are some major structural changes compared to the old act. Since the old act is mostly from, like I said, nearly 100 years ago, it shouldn't be surprising that the new modern legislation looks pretty different and is structured pretty differently, and it acts pretty differently. Where the old act just gave some skeleton requirements and let the corporation fill in the details, the new act has a much more structured approach. So it's a lot more specific about what you can and cannot do in terms of running the corporation. And in most cases, it operates on a default rule system. So what this means is where it gives the corporation certain options to choose from. If the corporation doesn't explicitly state its choices somewhere in its articles or bylaws, then the default in the act will automatically apply. So let me give you an example of this. So the corporation is allowed by the Act to specify any quorum for members' meetings that it wants. So you could make it 10%, 90%, it's up to you. But if you don't specify anything, the quorum will automatically be the default in the Act, which is 50%. So if you have no written rule about it, there's still a rule that's applying to you, and you need to be aware of that. On top of that, there are certain substantive changes compared to the old act, and some of them are pretty major and will have a pronounced effect on the way that certain corporations operate. So one of the big ones is the introduction of soliciting status, and that is given to corporations that have received more than $10,000 in money that they have solicited or have received from the government in any one of the previous 3 years. So if you have soliciting status, you're subject to certain rules that are different than non-soliciting corporations. So it creates kind of a two-tier scheme within the act that you may or may not be soliciting or not soliciting at any point, and you have to be aware of that. Um, I'm not going to go into the details of it today, but it is one major change to be aware of. Another big change is that if the corporation has a class of members that are non-voting, those members are now granted the absolute right to vote on certain fundamental changes to the corporation. So some of you may have classes of members that you don't really think about because they don't vote on things. Under the new act, if you keep them as members, even as non-voting members, then when certain big changes come around, they will be granted the power to vote on those things by the act. So if that's not something that you want, then you have to think about how you're going to address that and make certain changes um, to have the outcome that you want on that one. And this is something that has caused a bit of consternation, but there are ways to deal with it. Finally, one of the other big changes is that many corporations currently have ex officio directors, which is to say people who automatically get a position as a director as a result of holding some other position. So commonly, for example, this is the immediate past president. The immediate past president is automatically made a director of the corporation. Now, the act is says in no uncertain terms that all directors must be elected by the members to hold definite terms. So as you can understand, ex officio directors uh, don't meet that requirement, and they're actually explicitly prohibited by the act. So if you have any ex officio directors, that's another issue that you're going to have to think about how to deal with that change because you won't be allowed to have them anymore. Now, the continuance process itself, uh, we're going to talk a little bit about what it involves and how to go about doing it. Remembering again that the deadline to have all of this done is October 17th of the coming year. So you want to get started as soon as possible because as you'll see, there's some areas that might be a little involved and take a little bit of time. Now, the main part of the continuance process is analyzing the way that the corporation is currently running and identifying what needs to be changed to comply with the new act. Since corporations are governed by a combination of their governing documents and their bylaws, you're going to spend most of your time and effort kind of reviewing and revising these documents. The actual continuance itself just involves a couple of straightforward forms, and you can find them online, and they look straightforward, but what's really important is making sure that the forms are backed up by thorough, knowledgeable review, and that's where a lot of corporations can really benefit from some experienced legal assistance. So the first thing you should do is start by collecting up all of your governing documents, and that's the letters patent. for the corporation that establish the corporation, and any supplementary letters patent that have amended the letters patent since they were issued, as well as the bylaws and any amendments to the bylaws. Um, and so this includes making sure that the bylaws that you're working from are the valid bylaws, which means that they were passed properly by the corporation and they were approved by the minister, which is something that you've had to do under the old act in order to make the amendments official. They had to be approved by Corporations Canada. By the way, though, under the new act, the ministerial approval of bylaw amendments won't be required anymore. You just have to send them a copy of the amendments, but they don't have to approve it. So if you aren't sure which of your current bylaws are valid, or if you can't find them, or if you can't find the letters patent, or if you're not sure if there's been any supplementary letters patent, you can always contact Corporations Canada and ask for copies of these documents. So anything they have on file will be necessarily complete because you have to file them in order for them to be legally valid. So if they don't have it on file, then it probably isn't legally valid. Once you've gathered everything up, you need to go through and review all of the information together and ask yourself some questions. Does the information in them reflect the current way that the corporation is structured? Does it reflect the current governing process? What changes do you want to make and why do you want to make them? Are there any new provisions that you want to insert? If you're a charity, are there any changes to your objects that you might want to consider? So you can kind of come up with a wish list of changes, and take that wish list and compare it to what the CNCA does and does not allow you to do. So you can compare how you want your governance to look with what the CNCA allows the governance to look like. And if there are any clashes or inconsistencies with the act, then you're going to have to look for some solutions or workarounds to make sure the corporation gets what it wants as much as possible while still complying with the act. Um, Now we've been working on a number of continuances, and we've come up with solutions to several inconsistencies and problems. So if you need advice on that, we're always available for it. So once you've identified the changes that you want to make in order to kind of bring things into line with how the corporation is currently running and with what the new act says, then you can go ahead and start creating drafts of the new documents. So some of the changes that you have to make will probably revolve around the major substantive changes that we discussed, like non-voting members, ex officio directors. There's also the question of whether the changes should go into the bylaws or whether you should put them in the new governing documents, which are more permanent and difficult to change. And you need to draft the new bylaws with all the new changes in them for the members to approve. So this might mean starting with draft bylaws for the new act and just making small changes to them to reflect what your corporation needs. Or if your existing bylaws are really complicated to start with, then you may need to start from scratch. And of course, that takes longer and is more complicated, but it may be necessary. The next step is to address the articles of continuance. Now, the articles of continuance are going to be replacing the letters patent as the governing document of the corporation. So your letters patent after the continuance are no longer going to be relevant. They're going to be completely replaced by what's called the articles of continuance, and these come in the form of Form 4031, which Corporation Canada provides online. You can Google it, it's very easily available. And the form allows you to basically start fresh on the corporation in terms of the fact that it lets you make any changes you want uh, to the governing documents because it gets you to restate all of the information. So and it even gives you a chance to opportunity to change the name if that's something that you want to do. So it includes the name of the corporation, the province where the registered office is situated, the minimum and maximum number of directors, the objects or purposes of the corporation, any restrictions on the activities the corporation can carry on, the classes of members, a statement on how the corporation will distribute any property when it liquidates, and any other provisions that you might need or want to add. Um, so it seems fairly straightforward, and it's a chance for a lot of changes, but that in itself kind of makes it a little bit of a trap, because any changes you make to the way the corporation is currently set up may have consequences that you're not aware of. And registered charities especially need to be very careful with this, because the form will be reviewed by the CRA after you finish the continuance. And if they take issue with it, then it may place your charitable registration in jeopardy. The biggest thing that charities need to be careful about is changing their objects. Um, as a registered charity should know, it's registered mainly on the strength of its stated objects. So if you make any changes to them without consulting, a knowledgeable advisor, then you might be bringing trouble on yourself. And there's also a couple of other specific statements the CRA is looking for charities to include. So you need to be aware of that as well. You don't want to jeopardize your registration. So once all of that is approved, not approved, once it's all prepared, once you have the new bylaws drafted up and you've filled out the articles and you're satisfied that everything meets the corporation's requirements and it all complies with the new act, the last thing to do is to get the members to approve everything. Now, the articles and the permission to apply for continuance need an affirmative vote of at least two-thirds of the members who vote on them. For the bylaws, it depends what the corporation's current rules are, but it's probably a good idea to go for a two-thirds majority on those as well, just to really cover all your bases. So the way you go about getting it approved is you first prepare a special resolution um, to approve the articles in the bylaws and the continuance, and then you have to call a meeting of the members to vote on this resolution. Now, the resolution should specify that the bylaws are to take effect upon continuance, not right away, so that as soon as you switch over to the new act, your new bylaws kick in and not before, because you don't want any crossover. The other thing is that it's really important that this resolution be passed properly, which means you need to be careful that all of the procedures in the corporation's current bylaws for calling a meeting are being followed properly. So, for example, you need to make sure that you're giving the members the correct amount of notice. If your bylaws say 2 weeks' notice, you have to give them 2 weeks' notice at least. And you also have to make sure it's sent to all of the voting members and that they all have a chance to participate. That kind of procedural thing you should pay attention to it, because you don't want any challenges to this resolution. Now, hopefully, the resolution will pass with the two-thirds majority the first time around. But if the members want anything changed, if they're unhappy with the content of it, or discussions break out, you might be looking at calling a second meeting. Um, Especially for larger corporations, this can be really time consuming and expensive. And it also makes the October 17th deadline look a lot closer when you realize that that might happen. So once you have the members' approval, all that's left to do is to file. And you file all of the paperwork with Corporations Canada. So that's the 4031, which is the articles, as well as another form called Form 4002. And all this one does is lay out the address of the corporation and the names and addresses of the current directors. This form doesn't require member approval, so we usually suggest leaving it until after the meeting, in case there are any changes to the directors during the meeting, because it's a members meeting, so they always have the option of electing new directors. This is also a good time to send in the new bylaws. You don't actually have to send them in as part of the continuance. What they ask for is that you file them within 12 months of continuing. But since the bylaws are really integral to running the corporation under the new act, we always advise that you get this all done at once. Make sure all the bylaws are done and approved as part of the entire process. Send them in with the forms and just get it all finished and taken care of, so you don't have any confusion with being stuck with old bylaws under the new act. Now, once you file everything, the turnaround is pretty short. It's generally only a week or two. And what will happen is Corporations Canada will send you a certificate of continuance and copies of your new articles. And that'll be your proof that you were continued to the new act and you're all set up. And if you look at the certificate of continuance, it'll tell you the date on which the continuance took effect, and that's the date that your bylaws should be kicking in from. Now, if the corporation is also a registered charity, it needs to send a copy of the certificate, the articles, and the new bylaws that are signed by two directors and have a date on them. They need to send all of that into the CRA so the CRA can acknowledge that you continued and approve it. And this is the point where they'll be reviewing. Well, they claim they'll be reviewing your articles and so on to make sure that you still qualify as a charity. And if there are any changes, they may ask you about them. So next week on December 12th, Joel Sector from our office will be giving session 2 in the series, and he's going to be talking about what needs to be done once your continuance is approved, and he'll give you some tips on running the corporation under the new act. So that's all I have for you today. If there are any questions, just type them into the chat now and we can address them. So someone's asking what documents need to be sent into the CRA for charities. Just to recap, if you're a charity, after the continuance is done, you need to send them to the charities directorate of the CRA, send them a copy of the certificate of continuance, a copy of the new articles of continuance, the 4031, and also a copy of the new bylaws that has been signed by two of the directors and has an effective date on it. So another question, will the CRA review your documents before you file with Corporations Canada? No. You're going to send them in to the CRA after you filed everything. Um, if you are considering changing your objects, then before you do the continuance, you may want to ask the CRA to do a review of a change to your objects, which is something that they always do. They always offer. Um, or you can consult your lawyer and talk to them about that. How does an organization know if they have to do the continuance? If you are incorporated under Part 2 of the Canada Corporations Act and you haven't continued yet, then you have to continue. If you go onto Corporations Canada's website, uh, they have a tool that allows you to search for all federal corporations. You can type in the name of the corporation and look for it, and it'll tell you which act you're established under. If it says CCA Part 2, then you need to continue. So we have another question about the default rules in the Act, whether there's a document that lists together the default rules in the Act. Um, there, the best place to look is in the Act itself. Uh, Corporations Canada uh, does provide on their website kind of a summary of the main default rules. You can maybe make a link to that available afterwards. If our office did continuance for you, and you're a registered charity, then we send the documents into the CRA for you. So if you have any questions that are specific to your situation, you can always email me afterwards, and I can address those personally with you. So we have a question about dividing the responsibilities between the client and the lawyer. A lot of it depends on the size of the corporation and the level of complication involved, but generally, we for smaller corporations, we kind of just do the review and let you know our thoughts. If you have a few more people on the board, we might suggest that you strike a bylaw review committee and have the committee work together with a lawyer to come up with versions of a new draft of bylaws that everyone's happy with. So just to be clear, this only applies to federally incorporated charities and not for profits. So you have to be incorporated under the federal Canada Corporations Act Part 2. If you're incorporated provincially, this doesn't apply to you, but if you are in Ontario, be aware that a similar change is coming for them. Hasn't come into effect yet, but it should in the next year, so that's something to keep an eye on. So I think we're going to be making an audio recording of this presentation available on our website afterwards. We'll give you the information for that. So thanks everybody for joining us. I hope that you learned something today. And if you have any more questions, you can find more information on our website, which is drache.ca. And we also have an insights newsletter that you can sign up for. And you can also email me at tzannidakis@drache.ca, and we can speak by email. Thanks very much.